Welcome to Armor and Advocacy.
Welcome to Armor and Advocacy with Colin McNamee of McNamee Defense. Colin is an Ohio criminal defense attorney known for discreet, strategic representation in high-stakes criminal cases. His work focuses on protecting clients' rights, reputation, career, family, and future while avoiding unnecessary public exposure whenever possible. I'm Lisa Mosbey, your host, and today we're comparing how defense strategy shifts between misdemeanor and felony cases and why those differences matter early on. Welcome back, Colin. Thanks again for joining me.
Thank you so much, Lisa, for having me back. It's always a pleasure, and you ask the most insightful questions. I'm happy to provide some answers and guidance for our listeners.
Thank you. You know, Colin, at a high level, what actually separates a misdemeanor case from a felony case once you start working through it?
Good question, Lisa. At a high level, what separates a misdemeanor from a felony is punishment in terms of consequences, and also what we would term collateral consequences. So the obvious difference is felonies are eligible for prison punishment versus jail time. Felonies typically carry longer terms of incarceration, but also when one is convicted of a felony, you lose certain fundamental rights. You lose the right to vote, you lose the right to sit on a jury, you lose the right to hold public office, you lose the right to hold certain public licenses, you lose the right to keep and bear arms. And then the social consequences of people sort of judging you as if you were wearing the proverbial scarlet letter, F for felon. Think about going on field trips with your children or grandchildren, providing a chaperone for a church trip or a summer camp. That's not going to be available in 2026 to a person who has a felony conviction. Even a somewhat mundane or nonviolent felony conviction for theft or passing a bad check could very well prohibit forever someone's participation in those very important life events. And that's something we should be conscious of when we're defending a criminal case, particularly a felony.
And Colin, moving from a misdemeanor to a felony, how does the level of exposure change for a person facing that charge?
The level of exposure in terms of punishment, for instance, here in Ohio, Lisa, the maximum punishment for most misdemeanors under Ohio law is 180 days. And that's in a local county jail. There are a lot of probation or what they call community control sanctions available. There are almost no mandatory jail terms for most misdemeanor offenses except OVI and some other sort of esoteric offenses. When you move into felony land, as it were, the minimum penalty for a felony of the 5th degree, the lowest degree of felony, is 6 months in prison, up to 12 months in prison. Now, for felonies of the 4th and 5th degree, probation is often a very likely outcome, particularly for a defendant that does not have a criminal record or a serious criminal record. But nonetheless, being convicted of a felony raises the specter and creates a good likelihood that someone might have to serve prison time. And while jail is horrible and not an experience that I would wish on any person, prison is worse. And whatever we can do as a law firm, whatever I can do as a lawyer and as an advocate for my clients to avoid a prison sentence, particularly for somebody who's never been in trouble before, we're going to do that to the best of our ability and within the bounds of the law.
And Colin, with your experience and what you've seen defending these cases early in a case, what changes in your thinking when you know you're dealing with a felony instead of a misdemeanor?
When I know we're dealing with a felony charge or the prospect of a felony charge during an investigation, Lisa, this isn't to say that I don't take all cases seriously, because we do, but felonies are just more serious by definition. So it really causes us to focus up, to bring to bear any resources that we might be able to leverage on behalf of a client, whether that's private investigators, outside resources, specialists, social workers, persons of that sort who can help the client navigate the process, number one. And number two, start to set up circumstances which mitigate the likelihood of serious punishment. If I know a person is going to be charged, for instance, with a felony drug offense, I would urge that person to immediately get into drug counseling and to seek a person that could help them get and stay healthy so that we can demonstrate sobriety, as long a period of sobriety as possible during the pendency of the case. That tends to greatly reduce the likelihood of serious punishment in a drug possession matter, particularly in a low-level felony.
And a follow-up on felony cases. In a felony case, do you approach the evidence differently from the start?
We analyze and review the evidence very carefully, whether the case is a misdemeanor or a felony. And that's a good question, Lisa. However, in a felony case, typically there's a lot more evidence. There are more officers involved. There are more body camera videos to review. There's maybe more cruiser camera, dash camera, and Ring doorbell cameras to review, given the potential type of offense that might have been charged. So again, we take all matters seriously, whether or not they're felonies or misdemeanors. But when there's a felony, there is more work to do. And we factor that in when engaging the client initially, so that we can set expectations for the client and indicate to the client, this is the timeline on which the case is likely to play out, and to encourage them to sort of dig in for the long haul and find a way to get a support structure around them, whether that's family, friends, coworkers, myself as their lawyer, to be able to endure the process and to get the best possible outcome. Because if we're able to go the proverbial distance and resist the urge to resolve the case early, oftentimes a longer duration or timeline of a felony case works in the favor of a client, because we're able to achieve a better result under those circumstances. That's a very good question.
And Colin, I want to talk about that process. What changes in the way that a case moves through the court system between those two different levels?
It depends on the jurisdiction, right? If we're talking about Columbus, Ohio, Franklin County, felonies typically move very slowly through the system. We all enjoy a constitutional right to a speedy trial under state law. That's 270 days from charge or indictment, unless we're in custody and certain other factors exist. That's 9 months. That's a long time. But oftentimes, serious felony cases take longer than 9 months to resolve, because we want to be very careful about how we're going about reviewing the evidence, applying defenses, and negotiating with the prosecutor short of a trial before we get to that point where a client must decide whether or not they'd like to have the matter heard by a jury. Misdemeanors, the less serious degrees of misdemeanors, misdemeanor of the 4th degree, misdemeanor of the 3rd degree, on up to misdemeanor 1, those have shorter timetables by statute for speedy trial, and they tend to resolve a little bit more quickly. But again, in a big jurisdiction like Franklin County, we can often do things to delay the outcome of the case so that we can all work together, client, lawyer, and support structure, to achieve the best possible result. But if you're in a small county like Logan County and Bellefontaine, Ohio, the system often sticks to a very strict timeline, and we have to work within the bounds of that timeline, or else there's a sort of trial process forced on the back end. And the strategy is often dictated by that timeline.
Colin, your years of experience and time every day working on these cases, how do long-term consequences shape the decisions that you make in a felony case compared to a misdemeanor?
Long-term consequences are very important to consider for the client, right? These decisions in a case are ultimately not up to me as their lawyer, right? Whether to plead guilty, to have a trial, what offenses one would plead guilty to. Those are all decisions that are made by the client. And I want to position myself in a manner as to be able to give the best possible advice under the circumstances. And that starts with understanding who the client is. What's their family life? What's their level of education? How are they making a living? What is important to them, right? If their gun rights, for instance, are important to them, then that would dictate the strategy of the defense and how I might try to negotiate an outcome short of a trial to try and preserve their right to keep and possess firearms. Um, Knowing the client, understanding and appreciating the client's needs, and operating sort of as if I were the client or from the client's perspective truly empowers me to work through a case from start to finish with the client-centric focus on how best can we resolve this case to preserve the client's lifestyle, their way of life, their ability to earn and support their family moving forward.
I have to say, I am fascinated that you set the intentions up front on the direction and what you want for your client. That's new to me. I can honestly say I don't know many attorneys that I've interviewed who follow that practice. So, thank you for sharing that. I think it's really important for people to understand that approach. And I also want to ask, when you're dealing with a felony, what makes negotiation more complex or more limited?
Good question, Lisa. A lot of the things that we've already referenced earlier in this conversation, the seriousness of the offense, the potential punishment that's available. In a very serious, for instance, violent or drug trafficking crime, the prosecution has a lot of leverage. There's often mandatory prison terms that are available to the judge for sentencing in a serious felony case, and the prosecutor knows this full well. And they will often do what lawyers call charge or sentence bargaining, where they're working sort of backward from the punishment forward to the charge in trying to resolve the case. So the negotiations in a felony matter are far more complex. There are a lot more factors to consider when you have fundamental rights, prison time, serious consequences, the label of F for felon. Um, it can be an arduous process, and the prosecutor, not going to lie, has a lot of leverage in those circumstances, particularly when the evidence against a client is good. And that's not to say at all that it isn't worth it to immediately invest in a good defense lawyer. You should. That is always my advice. The earlier you invest in a good defense lawyer, the better your chances are for a positive outcome on the back end, however long that might take to achieve. And having an experienced defense lawyer like myself, knowing how to work through these negotiations, having the personal relationships and the rapport with the prosecutors so that they know when I say something, it's true, and that when I say something, it carries weight is very, very important in the context of that diplomatic process, trying to work toward a resolution short of trial. And if we can't reach a favorable resolution or a resolution that the client is willing to accept, we are ready, willing, and able to aggressively defend the case at the trial level, whether that's trying the case to the judge or trying it before a jury. We have a lot of experience. It's what lawyers really like to do. It's why I went to law schools, to have trials. But under most circumstances, Lisa, a trial is not in the best interest of a client because we like to bargain for certainty. And so we try to avoid trial by way of negotiation, trying to achieve, for instance, a dismissal. But when that's not possible, we are absolutely, having gone through the process, performed all the due diligence, investigation, and discovery work on the front end, ready to go to trial.
You know, every episode I ask you for a case, an idea of something that has happened in the past, where you can walk us through an example that shows how your strategy looked different in a felony case versus a misdemeanor.
So we'll take the example of drunk driving, what we call here in Ohio OVI, operating a vehicle while impaired. Um, there are misdemeanor versions of that offense, and there are felony versions of that offense. And on the felony side, they have fairly serious mandatory minimum jail or prison terms. So we work even harder in the context of a felony OVI to make sure that the client is receiving the appropriate services in the community, that they're getting with, linking with, staying with a counseling service, maybe even doing some term of rehabilitation. We also very diligently investigate the case, right? We look at all the scientific evidence, whether or not there was a breath or blood test performed, whether or not the urine test was properly performed and the urine collected appropriately. We look at all of these factors in investigating the case very carefully, because particularly in an OVI or a drunk driving case or drugged driving, if we're able to find some fault in the process or procedures of collecting evidence or the initial stop of a client on the roadside by a police officer, then we're able to get some traction in the case and sometimes defeat the charge. A very good question, Lisa.
Here's the final question for today, Colin. Early on, what tells you a case needs to be handled more aggressively to stay in control of it?
We always handle pretty much all of our cases fairly aggressively, Lisa. And I'm not sure if that's just an outgrowth of my personality and my strategy as a lawyer, but I take on matters in a fairly aggressive fashion. I want clients to know that they have me as their right-hand person, that I'm here to literally fight for them, not physically, but to go through the process and to advocate for them as aggressively as we possibly can within the bounds of reasonable practice. And so early on, what tells me that we need to be more aggressive is the seriousness of the case, the availability of evidence to the prosecution, right? If there is clearly a defect in the evidence on a felony OVI case, and that defect is clear early on, Lisa, then we will aggressively attack that defect and try to defeat the case and convince the prosecutor early on to dismiss the matter so that the client doesn't have to suffer through months and months of process and procedure just to get toward and achieve that eventual outcome. If we see a weakness, we go after it immediately. We go after it hard. And that's because we want to put the matter behind the client as soon as possible and enable them to get back to their life, to their family, and to have the specter and the weight of that charge removed from their shoulders.
Colin, I want to thank you for today. It's been eye-opening for me, and we appreciate you sharing your insights with the audience.
Thank you very much, Lisa. Appreciate these conversations. Thank you for the opportunity.
That's it for today's episode of Armor and Advocacy. Whether you're facing a misdemeanor or a felony charge in Ohio, the strategy behind your case can shape how it's handled from the very beginning. To learn more or schedule a confidential consultation, visit McNameeDefense.com or call 614-957-7629. Thanks for listening, and don't forget to subscribe, share, and leave a review. We'll see you next time.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.